Good afternoon. It's 12 noon, everyone, and we're going to go ahead and get started. We may have a few additional folks that will join the webinar, and we'll do our very best to keep this on schedule. As you all know, we're scheduled to go for an hour today. We hope to have an amount of time at the end for asking questions, but we wanted to point out that all of your phones are on mute during the course of the presentation. We do welcome your questions, but if you want to submit a question, please do that through the Q&A feature of the webinar or also in the chat feature that's available to you. And I hope what I just said made sense, because we do welcome your questions. One other point about questions, and that is we'll attempt to get to them during the course of the presentation. However, when the questions are submitted, they do come to us in a log, so we'll have a list of all the questions and attempt to respond to all of them at the end of the presentation. This is Cole West. I'm a partner with Holland & Hart. We welcome you by webinar to the firm. I'm here with my colleague, Matt Linton. We are colleagues in the Labor and Employment Practice Group and practice primarily in the area of workplace safety and health, and in our practice represent employers throughout the country on various workplace safety and health matters. I'm not sure how many of you are familiar with OSHA or deal with OSHA. The goal of the presentation today, just to provide an overview, is to give you a summary of what OSHA is, what its authority is, what you should know about what OSHA's mission and objective is when they come out to your site, what your strategy should be with respect to citations and enforcement actions, and then talk specifically about recent OSHA directives and guidance with respect to the healthcare industry, which is why I know most of you are joining us today, and we do appreciate your time. So first of all, I want to talk about OSHA. OSHA is an agency of the United States Department of Labor, and its charge comes from the Federal Occupational Safety and Health Act, which was enacted in the 1970s. What you should all understand is that while the Department of Labor continues from administration to administration, the head of the Occupational Safety and Health Administration is a political appointee that's appointed by the President and confirmed by the Senate. So as a result of that, although you wouldn't expect the agency to be a political animal, the agency does have some political responsibilities and political overtones, and a takeaway for you all to know is that politics will drive enforcement, and statistics, past inspections, and past citations will drive OSHA's future enforcement on your work site. So when we look at what OSHA's regulatory agenda is, we typically look to types of data that may be available in the public domain. And one of the areas of data that Matt and I regularly track is the data that's published by the Bureau of Labor Statistics. The graph that you see on your screen tracks the number and rate of fatal occupational injury rates by industry sector. This is the most recent set of fatality data that's from 2014. And you'll see that educational and health services are close to the bottom of this list in terms of the raw number of fatalities at 144 and the fatal industry rate of 0.2. So that's generally positive for the healthcare industry. But if we look at the next slide, which is looking at the incident rate and numbers of non-fatal occupational injuries and illnesses by private industry sector, you'll see that for non-fatalities, the healthcare and social assistance sector are at very high rates in terms of the numbers of non-fatal occupational injuries and illnesses as compared to other similar industries or other similar peer groups. And another one which places the healthcare industry at the top of the list, this is looking at the distribution of non-fatal occupational injuries and illnesses by private industry sector for 2013. And you'll see and this again is accounting for illnesses accounted for at the number in that particular sector, with illnesses at 39.8 and injuries at a very high number of 589.7 for the healthcare industry. This slide, and this just sort of reshuffling the data in a variety of ways. This is looking specifically at occupations, not necessarily industry groups. This showing that for injuries and illnesses for occupations, and the most recent data we had on this was from 2012, that nursing assistants had a very high number of cases at 44,100, and we expect that 2013 and 2014 data would be similar to those numbers. So the takeaway from that data is the following, that when OSHA sees when we see a spike in injuries and illnesses for a particular sector, there may be calls from industry groups, there may be demands from Congress for the agency to take action. And by talking about the agency as a political institution, the only takeaway from that is that the agenda may change from time to time. And the statistics and the visibility of the healthcare industry from an injury and illness standpoint have resulted in the healthcare industry definitely being on OSHA's radar screen in terms of enforcement. The upshot of that was that a consumer interest group, Public Citizen, recently published a report calling out the healthcare industry and requesting additional OSHA attention. And we recommend that you take a look at Public Citizen's report. The address is the one listed here on your screen. But this is the kind of information that's out in the public domain and something that OSHA is following closely in terms of the political pressure that may be on the agency to take action with respect to the healthcare industry. Most importantly, we're going to be spending most of today's presentation talking about the July 25th, 2015 guidance memo, which specifically was intended by the agency to address specific hazards for inpatient healthcare settings. And Matt's going to be talking to you about that in detail. So first of all, just an overview in terms of what the Occupational Safety and Health Agency is and what safety and health law is. So there are two kinds of law that are generally relevant to workplace safety and health law, and that is general legislation and specific regulations and standards. When we're talking about the Federal Occupational Safety and Health Administration, the agency was created pursuant to the Federal Occupational Safety and Health Act, and under that statute, OSHA is charged with promulgating and enforcing specific regulations and standards that accomplish the purposes of the statute. Those standards are enforced by regulatory agencies, and of course, specifically with respect to occupational safety and health, we're primarily talking about the Occupational Safety and Health Administration. With very few exceptions, and public employers are one of the exceptions that OSHA applies, or the Occupational Safety and Health laws apply to all employers in some fashion. And the other significant point here is that it doesn't matter why you violated a standard. There's strict liability. In essence, if you violate a standard, the agency is charged with issuing a citation for that violation, and it has no discretion in terms of whether or not to issue you a citation. For everyone on the phone, if you're in the healthcare sector, the Workplace Safety and Health Agency that has jurisdiction over your work site is the Occupational Safety and Health Administration. Under the statute, the agency has jurisdiction over workplaces in all U.S. states and territories, and it applies to workplaces except where other agencies may have jurisdiction, and specifically those are things like trucking, which is governed by the Surface Transportation Assistance Act and its regulations, the Mine Safety and Health Administration. So there are other agencies that regulate occupational safety and health But unless a statute specifically says that it has jurisdiction over those issues at your work site, OSHA is the default agency. OSHA has two types of standards that it promulgates and enforces: general industry standards and construction standards. The bottom line is that unless you're involved in a construction project or construction activity, your work site will be governed by the general industry standards. There are state plans or states that regulate occupational safety and health under approved state plans. I assume that most of the folks on the phone are from Idaho. Idaho is a federal OSHA jurisdiction, but you can see on this slide that there are 26 states, and a number of those fall in the Rocky Mountain region, that do regulate occupational safety and health. So if the workplace that you're discussing is in one of the states that has a state plan, you need to look specifically at the regulatory structure in that particular state. Otherwise, the federal OSHA standards will apply. I also want to point out, for a lot of the state plans, and primarily a lot of the state plans in the Rocky Mountain region, those state plans have incorporated, with some small exception, virtually the entire federal OSHA regulatory scheme. So how does OSHA get to your site? Well, OSHA has no regular inspection requirements under its statute, and if you compare that with an agency like the Mine Safety and Health Administration, where all mines are inspected at least twice a year and 4 times a year for underground mines, generally you're not going to receive or be the subject of an inspection by OSHA unless there's a complaint, unless you have a high visibility incident, or unless there's some report of an incident to OSHA. In early 2015, there was a significant change to the instances where employers are required to report to OSHA. It used to be that there was a fatality was required to be reported, and the inpatient hospitalization of 3 or more employees, that's been substantially pared back. Your obligation now is to report all fatalities within 8 hours and all work-related inpatient hospitalizations and amputations and loss of an eye within 24 hours. And what we've seen throughout 2015 is that the increased reporting obligations are leading to an increased presence of the agency in workplaces. I think we, in our conversations with OSHA, tend to see them as an agency that views itself as being helpful, but I think these words from Ronald Reagan certainly help to underscore the caution that you should have, and that is the 9 most terrifying words in the English language are, "I'm from the government and I'm here to help." They may be there to help, but understand that they're there in an enforcement capacity, and they're there to determine whether or not there have been violations of the law. So if OSHA does come to your site, many times the initial question that we get is, what do I do? Do I let them in? Do I ask them to get a warrant? What is their authority? What are my obligations with respect to producing documents? Do I have to participate in interviews? And it's important to understand what your rights are when OSHA arrives on your work site. First of all, OSHA has the authority to enter your site without a warrant if you consent to them being present. And I can't say that in very many instances in my 20-plus years of advising employers with respect to workplace safety and health, have I ever advised an employer to go get a warrant. But if you do refuse to provide access to the agency, they will go get a warrant, and I can assure you they will get access to your work site. So unless there is some specific circumstance why you would want to seek or ask the agency to seek a warrant, it's our general recommendation that you allow the agency to come on to your work site. Before we talk about the general duty clause, I just wanted to point out that the agency is obligated to hold with you at the commencement of the inspection an opening conference, and that's your opportunity to talk to the agency about why they're present. What's the scope of the inspection? How long do they anticipate that the inspection might take? And that's your opportunity to get clarification as to the scope of why the agency's there. If the agency subsequently expands the scope of its investigation beyond the scope that was described for you in the opening conference, you're entitled to have another opening conference for the agency to clarify that. So don't waive your opportunity to have a meaningful and substantive opening conference with OSHA when they arrive at your work site. Obviously, you have an obligation to comply with all OSHA standards, and for purposes of this discussion, we're going to be talking about the OSHA general industry standards. However, if OSHA does not have a specific regulation that deals with the hazard at issue, they may still cite you for a violation of what's called the General Duty Clause, which refers to Section 5A1 of the Occupational Safety and Health Act. The elements of the General Duty Clause are significant for purposes of this presentation today because in a lot of respects, the regulatory scheme does not exist for the hazards that OSHA is seeking to enforce in the healthcare context. However, if OSHA can establish that the employer or the industry had general knowledge of the hazard, if that hazard could potentially cause death or serious physical harm to employees, and if reasonable means existed to eliminate or to reduce the hazard, OSHA could cite the employer for a violation of the General Duty Clause under Section 5A1. You should know that General Duty Clause violations are automatically classified as serious citations or higher. There's no such thing as an other than serious General Duty Clause violation. And some of the specific examples that we're going to be getting into today, which relate to OSHA's initiatives in the healthcare area, are workplace violence and ergonomics, to name a couple. So if you get a citation, and OSHA is required to issue that citation to you within 180 days of the opening conference, OSHA has certain obligations in terms of what it has to inform you. First of all, OSHA has to provide you a factual description of what the violation of the standard was. Number two, they have to tell you what specific regulation you violated. And in the case of the General Duty Clause, they're required to notify you if they're citing you for a Section 5A1 violation. And number three, they have to tell you what classification the alleged violation has, whether it's other than serious, serious, willful, or repeat. After you receive citations, and in a federal OSHA jurisdiction, you have 15 working days, and I want to underscore the word working days. It's not 15 calendar days, 15 working days to do two things. You can request an informal conference with the agency in which you have an opportunity to discuss resolution of the citation without litigation or without a contest, or if you can't successfully resolve the citations or citation at an informal conference, 15 working days is also your deadline to contest. If you contest the citation, the case is assigned to a federal administrative law judge who works for the U.S. Department of Labor, and the lawyers for the U.S. Department of Labor and the solicitor's office will be working to either resolve the citation or to litigate the case before an administrative law judge. One key thing about contests under the Occupational Safety and Health Act, unlike some other workplace safety and health laws, if you timely contest a citation that's issued to you, it stays the period of abatement or the period by which OSHA is demanding that you correct a condition. So if you have a legitimate dispute with the agency, contesting it will prevent OSHA from further enforcement on that particular citation until your defenses can be adjudicated or at least resolved through informal discussion. Here are the definitions of the citations, and the main thing I want to underscore here is that the difference between an other than serious or serious citation largely relates to the negligence that accompanies the violation. And while I said at the outset of the discussion that strict liability applies to workplace safety and health violations and occupational safety and health citations, really what OSHA's looking at is what was the employer's knowledge of the condition, and what could they have done with reasonable diligence? Obviously, the higher or the longer the employer is known of the condition, the more significant negligence that could be attributed to that, and the more serious classification that could be applied to that. These are the key categories that you obviously would want to avoid. Any violation that's classified as willful, which is defined as consciously, intentionally, deliberately, and voluntarily violating a standard, or plainly indifferent. And again, heightened negligence will lead to a citation of willful. Repeat is reserved for substantially similar violations within 5 years. That changed several years back. It used to be 3, it's now 5 years, and it's by the same employer. So if you work for a large institutional employer with workplaces in a variety of locations, the employer as defined for purposes of a repeat citation is the entity, not the specific work site. The key thing you should recognize is that for willful and repeat citations, those are typically used by plaintiffs' lawyers to show that either a workers' comp shield should be defeated, or in a civil case that there was some willful conduct that should give rise to an award of punitive damages in a civil case. So law students spend a lot of time talking about what negligence is, and we spent some time sort of referring to it today in terms of understanding when a violation could become willful. And it largely boils down to these 3 questions. What did I know? When did I know it? And what did I do about it? If you have extensive knowledge, if that knowledge goes high into the management chain, and there's inaction by that management in terms of the condition or violative condition, you're risking a citation alleging some type of willful conduct. So anytime you're looking at a condition that could, or a circumstance that could give rise to an allegation that there's been a violation of an OSHA standard, I want you to remember these 3 questions, and I want you to think about designing your strategy to address that condition based on what knowledge you have, when you knew it, and what your failure to do something about it could result in. Really what OSHA is seeking here is, or looking for here, is whether or not there's some overt action or involvement of management personnel, and whether or not they directed or approved of actions that gave rise to a violative condition. All right, so with that, I appreciate your patience with me as I sort of provided some overview, but now sort of to the main event. Matt's going to walk you through the new guidance that OSHA has issued, and we'll then circle back with some other related topics. But Matt, take it away.
Thanks, Cole. So as Cole hinted at earlier, on June 25th this year, OSHA issued a guidance memo that identified particular areas of emphasis where the agency is going to be looking at for its enforcement in the inpatient hospital setting. So what does this, or who does this guidance apply to? It's extremely broad. We're talking about hospitals and nursing homes. There are some very specific definitions that are applicable here with respect to what a hospital is and what a nursing home is. I'm not going to read you this whole slide, but you know, as you can see, it's very broad. Industries in the hospital subsector provide medical, diagnostic, treatment services, including physician, nursing. I mean, it's you know, just about any facility that's giving some sort of medical care. And nursing and residential care facilities, you know, include the obvious ones, as well as you know, any sort of facility where the residents of that facility are receiving some sort of care by you know, either healthcare provider or even social services provider. That may include some level of nursing or psychiatric care. So what kind of inspections are going to be included as a part of OSHA's renewed interest in enforcement in this sector. It's going to include all OSHA inspections, what are known as programmed or unprogrammed. And the only thing to really understand with respect to programmed or unprogrammed is, an unprogrammed inspection is something where an employee calls OSHA reporting a hazard, or an accident occurs or an injury occurs, and as Cole mentioned earlier, we are seeing now with the heightened reporting requirements that employers will have an injury occur. Previously, it would not have been something they had to report to OSHA. Now they have to. They're calling OSHA, and OSHA dispatches an inspector out, usually within the next day or two, to look into what happened and look into the cause of the accident or injury. There could also be regional guidance or emphasis programs that apply to the particular area that you're in. So it's always good to check the local guidance that OSHA may have in a particular region, or what would be known as an emphasis program. An emphasis program has been long-standing for some time now on the nursing side, and with respect in particular to musculoskeletal injuries. That emphasis program is concluding, and that's one of the reasons why this new memo has come out, because while the emphasis program itself for OSHA looking at these types of occupational injuries, while that has concluded, the agency is not going away in this area. State plans are also included in this guidance memorandum of June 25th, and that's important to understand, given that there are a great number of state plans out there, but this memo is going to apply. So the meat of the June 25th guidance memorandum is really the focus that OSHA is making clear that it will have on particular hazards that are at issue in the hospital, inpatient hospital setting or nursing home setting. They are not surprising. Okay, so we've got musculoskeletal disorders relating to patient or resident handling, workplace violence, which is a huge issue, and it continues to be an area of emphasis for OSHA. Bloodborne pathogens. We all distinctly, I think, in the entire country now are keenly aware of the issues with respect to the Ebola outbreak last year, and the crisis that presented to hospitals across the country, and in terms of trying to protect their staff, and caught a lot of people flat-footed, and OSHA was really, quite frankly, right on top of this in trying to follow up on CDC guidance to ensure that the staff of these facilities were being adequately protected against Ebola. Tuberculosis has been an issue for some time. It was a much larger issue in the 1980s and early 1990s during the period where HIV was much more prevalent in terms of causing or resulting in individuals with tuberculosis, experiencing tuberculosis that otherwise, would not have, but because of their compromised immune system, tuberculosis became a serious issue. Indeed, there was a proposed rule that languished for some time in the 90s and to the early 2000s to deal specifically with tuberculosis. That rule never made it and died in the George W. Bush administration. However, tuberculosis continues to be a hazard, and OSHA has it on its list of areas where it will emphasize inspections. And finally, slips, trips, and falls, which are very common. And, you know, OSHA is not necessarily looking for the injuries that are going to kill people. They're looking for any sort of occupational injury, and slips, trips, and falls are very, very common in the hospital and nursing home setting. So just to get into a little more specific information with some numbers here with respect to each hazard. I'll start with musculoskeletal disorders. OSHA conducted 1,100 inspections in nursing and residential care facilities. And again, keep in mind, this is just nursing and residential care facilities in the period from April 5th, 2012 to April 5th, 2015. And ergonomic stressors were evaluated in 596 of these inspections. And of those, they generated 192 hazard alert letters to employers and 11 citations for OSHA's under OSHA's general duty clause for hazardous ergonomic conditions. Now you might be thinking, oh my God, we're only talking about 11 citations in this period. That seems like not much. They are under the general duty clause, so they're likely they're going to have to be serious, but they're not going to be more than $7,000. So why do we really care, aside from wanting to make sure that your staff is okay and protected? Well, it's not always necessarily the cost of the citation itself that is problematic. It's the cost of abatement that often is a serious issue for employers. And so while the citation itself may be relatively inexpensive, OSHA's requirement to abate, for example, the procedures that your facility may have in place that OSHA believes were related to ergonomic hazards could be quite expensive, could require new processes, could require the purchasing of new equipment, and that can get very, very expensive very quickly. Workplace violence is, as I mentioned, a very serious issue. NIOSH, the National Institute of Occupational Safety and Health, defines workplace violence as violent acts, including physical assaults and threats of assaults directed toward persons at work or on duty. My own father is an emergency physician, and I can't tell you how many times I hear from him, just from patients, the number of threats that he gets periodically, especially during the night shift. It is always an interesting experience, as I'm sure many of you know. In the healthcare and social assistance sector, 13% of the injuries and illnesses that were the result of violence. And the rate actually increased for the second year in a row to 16.2 cases per 10,000 full-time workers, up from 15.2 in 2012. And obviously, as we see, not just sort of your traditional view of workplace violence in terms of either patients or other employees that may engage in violent acts on the workplace. Now we are seeing the incidences of terrorism and other particular, mass shooting events that your facility and your operations are going to have to think about in terms of your planning and how to protect your employees. As I mentioned with Ebola, and HIV, of course, being another one of the most frequently cited standards in nursing and residential care facilities is the bloodborne pathogen standard. Now, something to mention here is that this is one of the specific standards that does apply. This is not going to be a general duty clause issue, and so OSHA actually has a bloodborne pathogen standard. It has been in place for some time, and it is worth re-reviewing the requirements of the standard. In particular, hospital and nursing home facilities are going to need to have bloodborne pathogen plans and how they handle the materials that may, for example, needle sticks is the classic example, but this is a very important area. It's not going away, and particularly when we have a sudden, more emergent situation like the Ebola outbreak, having the proper plan and procedures in place from the outset will go a long way in the unlikely or unfortunate event that your facility is faced with some sort of more emergent or catastrophic issue that you can believe that OSHA will show up afterwards to find out what was done and what could have been done better. Tuberculosis is an interesting one. It's been around for so long, and yet it continues to kind of pop up with increasing incidences around the world in particular, but even in the United States among persons 65 years of age or older, and obviously here in nursing home facilities are faced with individuals that are of advanced age, and being aware of the hazard of tuberculosis is step one, and OSHA is looking for facilities to have not only reviewed the CDC guidance, but establish and determine whether what the hazards are in your facility, but then establish plans largely revolving around respiratory protection plans and all of the steps that are required as a part of a respiratory protection plan. It is, for example, when it comes to the types of respirators that may be used, negative pressure environments for, isolation rooms for patients that may have tuberculosis, and as well as just the basic testing that is required for individuals who are entering employment, for example, in a nursing home, the employer must pay for the TB testing to determine whether that individual has, upon initiation of employment, tuberculosis, and then ongoing testing to monitor and conduct medical surveillance of employees to determine whether they've been exposed to TB and then how to deal with it. Finally, slips, trips, and falls. Again, these are non-fatal, but they account for 68.6% of all reported cases of days away from work. So they're not only, costing your employees, whatever pain and suffering they may incur because of it, but they're costing employers a lot of money because you're dealing with people that are missing work and having to fill gaps. So these are nuts and bolts type things that OSHA is interested in identifying and citing. There are other hazards as well. These are going to come under general duty clause issues, but a common hazard, as I'm sure many of you are familiar with, is dealing with drug-resistant organisms, staph virus, MRSA, and the procedures that are in place to protect your workers from MRSA infections or other, as they are called, MDROs, are going to be key. And here, documentation also is just to strike the chord. I think we're going to get into that a little more later, but having the documented procedures in place for how things are done in your facility to protect employees is really half the battle when OSHA is looking at what is happening at your facility. And finally, hazardous chemicals. There are clearly drugs that are potentially hazardous, as well as simple stuff like sanitizers and disinfectants, anesthetic gases. These are all commonly encountered in inpatient healthcare facilities. So, what can we do? What can you do? And I think one thing to address is looking at OSHA's instructions that are available publicly from their website. These links in here are actually live links. If you download the presentation, it'll take you straight to the instructions that describe the enforcement procedures for investigating or inspecting workplace violence incidents. This is going to tell you how OSHA's inspectors are going to be evaluating these hazards and how they're going to look at issuing citations, so they're very informative. Bloodborne pathogens has similar instructions. Same for tuberculosis. Note that tuberculosis actually has a relatively new instruction that came out just this past year. There was a previous one that went back all the way to the 1990s that has now been superseded by this new guidance, and it's important to review it and learn what has changed. The document actually identifies some specific areas that have changed in terms of guidance, largely based on the CDC's new guidance that has come out.
Hey, Matt, let me just interject here for a second, because one question we often get is, I'm looking at a guidance document. Does it have the force and effect of a regulation? Can OSHA cite me for violating a guidance document? What's your response to that?
It's a good question, Cole. No, these guidance instructions are not law. You cannot be cited for failing to follow a guidance document. However, I think it's our experience that sometimes OSHA seems to think they're law.
And I think it does go to what's sort of reminding everyone of the discussion earlier in the hour about the general duty clause. Keep in mind that all OSHA has to establish for a general duty clause violation is that it's a generally recognized hazard, either by the employer or for the industry. So everyone should consider that a guidance document is completely fair game in terms of the agency using it to establish what's a generally recognized hazard which could pose a risk of serious harm to employees. Thus, the significance of knowing what the guidance documents are, what they say, how they're implemented, how they're enforced, how they're interpreted, and most importantly, how you communicate those guidance documents to your employees in your safety and health compliance plans.
And again, just pointing to another instruction document here for slips, trips, and falls. Check it out. It will be very helpful when crafting your plans. And this is kind of a general comment here, but even if OSHA attends or comes to your facility, responding, for example, to a complaint from an employee of a hazardous condition, an OSHA inspector can always expand the scope of their inspection to include other hazards. So they, as Cole mentioned, when they show up at your door and they say, "I'm from the government, I'm here to help," they're not necessarily going to narrowly confine their review of your procedures.
And I do want to add sort of one caveat to the Reagan rule that the government isn't necessarily there to help. OSHA does have a fairly robust compliance assistance division. Some of those are a little better defined under some state plans. And reaching out to the compliance assistance division can occasionally be a good idea. Technically, the compliance assistance folks are prevented from talking to the enforcement division of the agency, so that if you seek assistance from compliance assistance and the person who comes out to your site from OSHA on the compliance assistance side learns of something that could potentially be a violation, they're prohibited from sharing that information with the enforcement side. Call me a skeptic as to whether those lines are honored, but just recognize that there is some risk anytime you're talking to OSHA about a condition that could give rise to a violation of a standard. So we're going to talk just a little bit in terms of how you take the substance of what Matt talked about today, and I think the important takeaway there is you know exactly what OSHA is going to be looking for under this most recent guidance. They've told us specifically what areas they're going to be focusing on, because keep in mind they're responding to certain political pressures in terms of trends that are being seen in the industry. So what's the most important thing for you to do? Well, I think you've got to audit your existing programs. You've got to look to see where your particular where your particular company may stand with respect to its compliance in each of the areas that Matt identified. Are there policies that need to be updated? Are your training materials current? Have you actually done an audit of your systems to make sure that you're in compliance? So I think a good assessment of where you presently stand is a good idea. I think the other important part is to understand and educate your team about what happens if OSHA actually does come on site. What happens if OSHA sends you a complaint letter asking for additional information about a specific subject? You need to discuss in advance who's going to work with OSHA, who's going to respond to document requests, how are you going to handle opening and closing conferences, who are going to be representatives of the management team and who are going to be representatives of your employees, and if you're a union environment, how are you going to be specifically interacting with your collective bargaining unit in terms of dealing with OSHA. Most importantly, how are you going to train your employees? As we'll talk about in a few minutes, training is one of the key components in terms of showing compliance. It's also one of the key components in terms of showing that you should not be held liable for a violation due to employee misconduct. There's a big disconnect in the OSHA regulations given the fact that the vast majority of the regulations that you see deal with unsafe conditions. However, most of the occupational injuries and fatalities are caused by unsafe acts. And really what this requires is an effective showing by the employer that you have communicated and provided effective training to your employees regarding the hazards in which they're going to encounter. And specifically with respect to the guidance, how effective is the training to deal with these specific topics? And finally, how do all of these things contribute to your overall safety culture? What's the perception that your employees have in terms of the importance of compliance? Does management effectively and regularly communicate to employees the importance of compliance? And do your policies demonstrate a strong safety culture? So let's talk about the OSHA response team piece of this. We think it's critical that you have established in advance who your contact person will be for any OSHA inspection. Typically for work sites, if you have somebody who's a health and safety professional or who's generally responsible for administering compliance with OSHA regulations, that person needs to be designated as the point person for OSHA contact. That point person should remain the same throughout the OSHA inspection. You should reach out to either your in-house legal counsel or your outside legal counsel to let them know that OSHA's commenced an inspection and to obtain any advice that may relate to scope issues or employee rights issues that may be arising from the initiation of the inspection. You need to decide who's going to be producing records to OSHA. And I go back up to that first bullet point. Typically, it's our recommendation that the point person is also the person that's going to be responsible for producing records to OSHA. We usually ask that OSHA provide records requests in writing and that you keep a copy of any document you provide to the agency, and of course it's important that you never produce an original document to the agency. It's also important that your employees understand what their rights are with respect to OSHA being on site. And there are a number of rights that employees have, and there's certainly nothing wrong with us communicating to our employees what those rights are. I think we have a specific slide that deals with employee rights, and we're going to come again. There we go. We'll come back up to those slides, but I just wanted to go specifically to employee rights. Employees are never required to talk to an OSHA investigator, and there's nothing wrong with us informing our employees of that in advance. It's somewhat more sticky for us to be telling employees that they have the right to not talk to an investigator once OSHA's already on site. So all of these points that are on this slide, I think, bear repeating in your general safety training. Your employees have the right to have access to counsel during the course of an inspection. If they choose to be interviewed, and participating in an interview is a voluntary process, unless OSHA goes to the effort of getting a subpoena, then an employee can discontinue an interview at any point. They have the right to refuse to be recorded. They have the right to refuse to sign a written statement. The employees have the right to present exculpatory information to OSHA, and they have the right to evaluate the direction of the investigation by asking questions. So certainly your employees and the employer generally has significant rights with respect to an OSHA inspection. Is an important part of your safety training to make sure that you communicate those to employees in advance. So we're going to go back to talking just quickly about responding to document requests. OSHA's authority with respect to documents extends to records that are required to be maintained under an OSHA standard. So with respect to the topics that Matt outlined for you, you're required to have certain written plans to comply in those areas. So if OSHA comes out to conduct an inspection or an emphasis inspection with respect to this directive, you should expect that OSHA will ask to see all of those required plans. If OSHA asks you for documents that fall outside the scope of a required plan, you do have some discretion to ask why the record's required or ask why OSHA is requesting the record, and try to arrive at some mutually agreeable resolution in terms of whether or not you're going to make those records available. And as I said before, when talking about records requests, it's very, very important to keep track specifically of what OSHA is asking for you to produce and what you've provided in terms of records. And if you're not sure of whether or not a record should be produced, and it falls outside the scope of something that's mandatory, we think it's a good idea for you to seek counsel, either inside your company or to outside counsel in terms of whether or not you may have an objection to producing that record.
And this is Matt, just jumping in very quickly. Cole and I have made a little video that we're going to be releasing soon. Probably will get broadcast out on the same list about how you learned of this webinar, where we're going to talk in a little more detail on responding to document requests. So be on the lookout for that if you're interested.
One of the beautiful things of OSHA law is that if you're an employer and you have done everything you can do to effectively establish policies, communicate those policies, enforce policies, and discipline violations of those policies, the employee misconduct defense provides you a complete defense. It's a silver bullet to a violation. What you see on the screen are the elements of what that defense requires. Typically, the biggest trip up is the effectiveness of the training and the effectiveness of the enforcement of a policy. We're generally good at having policies that sound good, that look good, but in reality what OSHA is going to be looking at is, what did you specifically communicate to employees about this topic? How effective was that training? How effectively was it received by the employees? And we know how effectively it was received in terms of the ability of the employees to act on the training, and specifically regarding our ability to show that there's general compliance with the policy. So generally, on all of the specific substantive topics that Matt outlined for you, go back, take a look at your training materials that are in each of these areas and make sure that they're adequate, make sure that they're substantive, and ask your employees to give you feedback in terms of how effective that training is. The important point here is that training is given in a variety of ways. And I know when your employees are sitting in a classroom, it's pretty easy to understand that that is training. However, coaching and counseling of employees in perhaps a disciplinary setting is also an opportunity for you to show that you're effectively training your employees. You may have shift meetings, you may have weekly safety meetings, you may have monthly safety topics. Make sure that you document that you're giving training in those areas. So for example, if you have a monthly training on lifting techniques, and you want to be able to establish, if OSHA comes out in an enforcement context and is talking to you about MSDs, that you've been effectively providing strategies to your employees in terms of dealing with that hazard, which is OSHA certainly going to say is generally recognized. I think we hit that slide. Before we leave you today, we're going to just spend just a little bit of time on whistleblowers, because I think it's a significant risk in terms of understanding when OSHA might come onto your site. I think Matt talked to you about these special emphasis topics giving rise to OSHA inspections, but one of the most common ways that OSHA ends up opening an inspection is if they receive a complaint about a condition in your workplace. Whistleblowers also have specific rights under Section 11C of the Occupational Safety and Health Act to be protected from retaliation if they engage in something that's deemed to be protected activity. And protected activity includes employees making safety complaints or raising safety issues to their employers. So here are sort of the golden rules with respect to whistleblowers, and I think these are fairly straightforward. They're common sense, but I think, you know, failure to do all four of them or any one of the four could result in increased risk for a complaint. First of all, you should address all complaints in good faith, 100% of the time. And if you're not able, or if the person who's receiving the complaint has some reason why they can't respond in a calm, professional manner, make sure that you assign someone to address that complaint in a calm, professional manner. If there's some question about whether or not there's a hazard that's immediately posed by the complaint, you need to address it immediately to enhance your credibility with the complaining employee. And then probably the most important one, and one that Matt and I see typically not followed through on, and that is, did you effectively communicate to the complaining employee after you were finished with the process in terms of what the resolution was? We have provided on this sheet some additional resources for you to drill down a little bit further into these topics. You know, Matt and I probably could have done an hour-long webinar on any one of these topics, but our goal here is to give you a good sense of what the agency is currently focusing on, what the agency is utilizing to evaluate which workplaces should be the focus of their enforcement activities, and what you should be expecting when OSHA comes on site. Matt, anything you'd like to say with respect to these resource documents?
No, I just follow up saying that OSHA has actually quite a bit of information on its website. There's a wealth of information on there, although it's not always perfectly up to date. In particular, just recently in looking at a tuberculosis question, note that OSHA's what they call, I think, e-tool for giving guidance on tuberculosis procedures in the hospital setting refers to the old, now superseded 1990s era tuberculosis guidance. And so I encourage you to make sure that you are always double checking that you're looking at the latest document.
Finally, I'll say in conclusion that while Matt and I reside in Denver, we practice throughout the region and throughout the country. We look forward to having the opportunity to talk with you specifically about any specific issues or questions that you might want to pose to us. We appreciate your interest in the webinar. We are proud of the work that we do with the healthcare employers, and we thank you for your participation and attendance in today's webinar. With that, any questions that we see on the screen at this point?
So feel free to send us any questions. Right now, we're not seeing anything. We'll give it a few minutes. If you have any questions, you can type it into the Q&A box or in the chat field. Or, of course, always happy to answer if you want to give either one of us a call or send us an email. Always happy to talk. A follow-up question on the webinar. So we'll just hang for a moment. Otherwise, we'll move on. You may see we do keep a blog that we post to regularly called the Workplace Safety Report. We cover kind of all workplace safety-related topics on there. We try to post quick snippets of updates and information related to a variety of industries, healthcare being one of them, and you feel free to check it out if you are interested.
We don't see any questions or comments coming across the screen here. So with that, we will bid you a good afternoon. And again, thank you for your participation in today's webinar.